Good morning, gentlemen.
Good morning.
Good morning, Judge.
Can I have appearances for the record?
My name is Sam Goldberg, and I'm with Corey and Goldberg Law Firm.
Representing?
I'm representing Mr. Jay Gossard.
Okay.
Your Honor, my name is Jason Spiller, Spiller and Grove Law Firm, and I represent the plaintiff, Lisa Marks, in this matter.
All right, so it's defendant's motion. I'll hear from the defense first.
We believe that Mr. Jay Gossard's motion should be set aside. This motion to set aside the default judgment should be set aside because we fulfilled the three...
Well, let me just stop you for 1 second. Can you just give me a small recitation of what the case is about?
Pretty much what happened is the complaint got sent in the mail.
No. What I'm asking is, what is the case about?
Oh, well, the case is simple.
The underlying facts.
The underlying facts are this. The defendant is a bus driver. A woman was on his bus. She got off the bus. She crossed the street, and a car hits her. A random car, has nothing to do with the defendant, hits her.
Let me stop you right there. If I turn to the plaintiff and I ask, it sounds to me, based upon what he just said, that somewhere in this case there might be a meritorious defense. Do you agree? Considering that the defendant standing before him... Well, let me back up. Do you agree with the facts as he's just explaining to the court?
The facts from what my client has told me are a little different from what he has just explained to you today.
Well, all right. Well, can I just, to the essential fact I care about right now as I sit here, are you willing to agree that a party other than the defendant hit your client?
Yes, Your Honor.
Are you willing to agree that there is a meritorious defense?
Yes.
Okay.
There is a meritorious defense.
Now, did he plead a meritorious defense in his motion?
Yes.
To set aside default?
Yes.
Okay. So let's put that aside. Do you disagree with the fact that there's excusable neglect?
Yes, I do.
Okay. Let me hear what the defense has to say about excusable neglect. What is the excusable neglect? Before you get to the law, counselor, what's the excusable neglect?
The excusable neglect is this. He did not look at this piece of mail. This piece of mail got sent with all his other mail. He did not know this was from the court.
This is Mr. Gossard.
Correct. Mr. Gossard had no idea this was from the court. It came with all of his other mail. He usually places all of his mail in his sock drawer. And this complaint got placed in the sock drawer with all of his other mail.
All right, let me stop you right there, though. You do represent the bus company as well, correct?
Correct.
All right, and did you answer on behalf of the bus company?
Correct, yes.
Okay, so I'm just thinking out loud here, okay? So I want you to correct me where I'm wrong. But if you answered on behalf of the bus company, then you must have looked at the style of the case and seen that your employee, Mr. Gossard, was listed. If you saw that Mr. Gossard was listed, you would have been able to at least check the docket and see if he'd been served. I'm guessing you didn't do that because default judgment's been entered.
We did not do that.
So we can then say that you have some culpability in the fact that the answer was not filed, correct?
We could say that.
Okay.
But on the same hand...
Well, hang on a second. Well, I think that's a good admission on your part. Now let me turn back to the plaintiff. So if he's going to say, look, part of this... and I understand what you're saying about the sock drawer, okay? We'll get to the sock drawer later. Does his motion at all mention, by the way, the fact that the attorneys might be somewhat responsible for this getting entered against them?
No, Your Honor.
Okay. But let's assume that's the case. Is it really plaintiff's contention that I should then not set aside the default judgment based upon the fact, and I mean no offense to you, defense counsel, but is the plaintiff suggesting that I shouldn't set aside the default judgment because this particular defendant chose poor counsel and they're just unlucky?
Under those circumstances, no, I wouldn't contend that, but under the contention of what he has explained in his motion was primarily that it was the actual defendant's fault.
Okay. You take issue with it being the defendant's fault?
Yes.
Okay, let's put that aside.
Okay.
Are you saying that I should set this aside, however, because it's his fault?
Well, I believe, Your Honor, case law tends to state that excusable neglect arises when there is mere mistake, secretarial, clerical error, or human error of that nature. It says that
it should be set aside or should not?
Should be set aside, but for what I have prepared on behalf for our hearing today is based on the fact that the defendant was just merely ignorant and he just kind of disregarded the...
Well, I understand. We only have 5 minutes here, counsel, and maybe you don't have case law on this. I'm just asking you, should the defendant be denied his day in court because the defendant chose poor counsel? I'm just asking you a simple question.
No, that's not why he should be denied, no.
But you contend he should still be denied?
Yes. For other reasons.
And those reasons are?
For the defendant's own fault.
Okay. For counsel for the defense, who's the primarily responsible party for this default being entered against the defendant?
Well, basically,
The client or your office?
I would say my office right now. And also, I'd like to say also that we did...
Why didn't you write in your motion then, Counselor? Why did you do a whole motion on something that wasn't the primary basis for setting aside the default?
Well, I listened to what my defendant said, and that was the first thing that came to mind. I thought it was responsible to write this. I thought these were the facts of the case. But you are seeing...
Are you telling the court that you listened to what your client said?
That's exactly
and thought
what
I'm going to say that this is what the problem is? It's not nothing to do with myself?
Well, Your Honor, you know what? After hearing what you said, I completely agree with you.
That's wise, Counselor. It's very wise. All right, we're gonna stop right there. Now, here's what I think about this. You see, a lot of this didn't deal with the case law because you don't have a lot of time to get in the case law for motion counting. You did the right thing on agreeing with the meritorious defense, okay? Because you concede what you can concede in court. You're going to save time, and you can kind of tell the judge is going that way anyway. Yeah. You did a good job in conceding that you were probably somewhat responsible for the problem that you have right now, right?
Yeah.
So when I come back to you, I'm really asking you an open-ended equity question. And your answer probably should be yes. It doesn't matter if it's his defense attorney's fault. But the problem is, I know what you're thinking. You're probably thinking, I don't have a whole hell of a lot of case law on that. Right? I mean, you don't have anything to cite. But you can always say, but that's fine. But think about the position you're in. You can just simply answer it. Now you're open field running. You can say, you know what, Judge? The answer to the question is no. You shouldn't set aside because he picked poor counsel. You know, we have rules, and the reason we have rules is so the attorneys can follow them. We all operate by those rules. And if counsel thought that was a really good reason, I would be prepared to argue today, Judge, because he would have put it in his motion. But he didn't do that. You see what I'm saying?
Right.
Yeah, real quick. But by saying that you do the thing you should not do, which is, I don't know where to go, this is something you shouldn't concede because you're conceding your whole argument. You shouldn't say, yeah, I'm going to let him have the whole thing, and say that the default judgment should be set aside because of the attorney's fault. You see? Now, when I get back to you, you do the smart thing. Don't mess with it. You see what I'm saying? You sit there and I say, listen, counselor, is it your fault or your client's? Like, that's all my fault, Judge, because you saw which way the argument went.
Right.
If you go back and say it's your client's fault, then you're playing back into his hands. He's going to unload all of the case law that you know he's brimming to throw at you. So you don't do that. That's how hearings go. It's like a sword fight that lasts 5 seconds, right? And it's parry and thrust, and then who got who. But I don't want you to feel. I think you both did a nice job. Both of you did a nice job. And I don't want you to feel discouraged because because I told you you conceded your whole case. Don't feel that way. This is a perfect example of learning. When to concede and when not to.
It's just that the whole track of the excusable neglect idea went in a different direction as to what I was prepared to respond.
100%.
That's the only thing. So
and that's how motion counter is. Yeah, I'm not doubting the fact that you are here prepared. I'm not doubting that at all. I guarantee.
For your other side.
No, but I think you are prepared. There's no doubt about it. The only thing is that you can't ever anticipate how the argument's going to go. So no matter how much, you could have sat, that's what I was trying to tell the class, you could have sat and researched this for 5 hours, prepared for 4 days, but you don't know that I'm going to wind up taking this thing in this crazy curlicue way, and that could really be how the hearing.
Yeah, I was expecting 2.5 minutes.
No,
this was completely.
That's not how it goes.
Completely different.
That's not how it goes.
Yeah.
I mean, I've had cases where I'm up there arguing, and it's like I haven't said a word, and I'm winning. And I still want to talk. And you're like, I'm not going to say anything. I've been preparing this for 4 hours. I'm about to win. I haven't said a damn thing. I'm going to sit down. Best argument ever made. Said, thanks, Judge, and left. Right?
Yeah.
So I think you both did a nice job.